Okay, we are online now. So I think we can start. Uh, so just a second. Yeah, we can start. So good evening or good morning to the audience and to our speakers, depending on from where you are joining us. We are glad to welcome you on the webinar, which is jointly hosted by the Ukrainian Arbitration Association and ICC Ukraine, Arbitration Committee of ICC Ukraine. The topic of our webinar today is quite topical, I would say. We'll be speaking about the seizure of Russian corporate assets, how Russian corporations could be prosecuted for war crimes, and how damages caused by the Russian aggression can be compensated from the Russian corporate assets. This topic has been discussed quite widely. The topic of war damages has been discussed quite widely in the recent 2 years since the Russian aggression started, the full-scale Russian aggression started. However, it was, I think, mainly concentrated, and I think this remains the focus now, on the Russian sovereign assets, which are frozen in various countries across the globe. The topic of our discussion today will be slightly different, as we'll try to concentrate not on the sovereign assets, but on the Russian corporate assets. So let me introduce you our distinguished speaker. We have today with us Professor Michael Kelly from Creighton University, Professor, and as well as Professor Milena Stereo from Cleveland State University. Professor Stereo is also a managing director of Public International Law and Policy Group. And Professor Kelly is also an associate fellow of this, of the PILPG. And both Professor Kelly and Professor Stereo were co-authors of the very recently published white paper on the seizure of Russian corporate assets. If I'm not mistaken, it was released just last week. It was published under the auspices of the PILPG. And this will be basically one of the topics which we will be discussing today, this white paper. I am Secretary General of the Ukrainian Arbitration Association. Will be moderating this discussion today together with Anna Tkachova. Anna is counsel at in the cross-border disputes team at Asters. So I think I can now give the floor to Professor Kelly and Professor Stereo to provide the general overview of the recently published white paper. As it was published really recently and just a week ago, I think many of our audience have not read it or are not aware of it. So I think it will be helpful if you present generally why you considered it necessary, what it provides, to whom it is addressed, and so on and so forth. So please, the floor is yours.
Well, thank you, Sergei Uvarov and Anna Chakova, for hosting us for this webinar. And thanks to Paul Williams and the Public International Law and Policy Group for releasing our research and helping with the effort to bring justice to Ukraine. I'm going to give a brief overview of the structure of the paper and introduce also my co-authors. And then Professor Stereo will take us through the litigation process. Our team that we assembled to develop this white paper, in addition to myself and Professor Stereo, includes Associate Professor Koval, Dmitro Koval, from the National University of Kyiv Mohyla Academy. He's now a visiting scholar at Stanford University. And Federica D'Alessandra, who's the executive director of the International Peace and Security Program and the deputy director of Ethics, Law, and Armed Conflict Institute at Oxford University's Blavatnik School of Government in New York City. The thing I wanted to talk about a little bit first, before we get into the paper itself, is the rationale for it. Why did we undertake this project? So that you can understand a little bit better our approach. As Sergey mentioned, most of the discussion about frozen Russian assets in Western capitals due to sanctions, and this is mostly European capitals, revolves around the assets of the Russian central bank. The Russian central bank assets are sovereign assets and therefore largely considered untouchable for a variety of reasons. Now, there are some discussions now at the G7 and other areas about the possibility of releasing those, but that would create a whole new regime and a waiver system that if you commit aggression, you waive your right to those assets. That hasn't happened yet, and I'm not sure that it will ever actually happen. The second class of assets that are also frozen because of the sanctions regimes are the private assets, the assets of Russian corporations and oligarchs. There's been much less discussion about seizing those frozen assets, which are also sitting in many of these capitals, the ones that have been located. It's been quite a process to try to identify them because Russian companies tend to try to make it secret where their assets are. And so this creates quite a lot of detective work. I joined the American Society of International Law when it came to Lviv, Ukraine in December, which is where I met Anna Chakova, for our summit, bilateral summit with the Ukrainian International Law Association to commemorate Human Rights Day. And so that's where we began discussing the draft version of this white paper, and it became a better paper because of that visit and the discussion with our Ukrainian colleagues. The first thing I wanted to point out was the Lugano principles. I'm sure that everyone is aware that in 2022, Western nations and donor nations met in Lugano, Switzerland, and developed 7 principles to guide them in the reconstruction of Ukraine. And here's the main principles: partnership, reform focus, transparency, accountability, and rule of law, democratic participation, multi-stakeholder engagement. That means everyone is at the table, not just governments, gender equality and inclusion, and finally, sustainability. This white paper supports point number 3, which is transparency, accountability, and rule of law. And so one of the themes that continues throughout the entire paper is that if Ukraine is going to pursue seizure of frozen corporate assets, it needs to do it through a rule of law process. And this dovetails with how Ukraine has been conducting itself in the aftermath of the invasion. Ukraine has tried very hard to sustain itself as a rule of law nation because it knows that a rule of law nation is what you need if you're going to secure your democracy. If you don't have the rule of law, you're not going to have a sustainable democracy. We saw this, of course, in the wake of the collapse of the Soviet Union. Out of the 15 units that emerged from the former Soviet Empire, only 3 were sustainable democracies because they were rule of law platforms: Estonia, Latvia, and Lithuania. They were rule of law countries before they were absorbed into the Soviet Union. Russia couldn't sustain its democracy because it was not a rule of law nation. It never has been, and it is not today. Ukraine is the only other one of that group that has tried to put down the foundations of the rule of law. And so during the 25 years since its independence, it has, gotten closer and farther away and closer and farther away to sustaining its democracy. Now, in the wake of the invasion, Ukraine under the Zelensky government has been very serious about rooting out corruption, sustaining the rule of law, because it knows it needs that to become a democracy and fully be embraced by the European Union, by NATO, and all of the other organizations that it's looking for. This white paper supports that process because it helps lay a rule of law foundation for seizure of those assets. When we look at the litigation matrix that Professor Stereo is going to take you through in more detail, we see that some of the keys are identifying where the assets are, matching those to the companies, matching the companies to war crimes that happen, and then bringing a Russian company to court in Ukraine, either in a civil posture or a criminal posture, attaching assets to a judgment award and then transferring those assets back to Ukraine. The assets themselves are going to be used ideally in the rebuilding process. The World Bank has estimated that it will cost $411 billion to rebuild Ukraine. Now, this estimate is a year old. This is going to be much larger now when they redo it for 2024. But this is the metric that we have. And you'll notice in this chart that maybe a third in purple here are dedicated to rebuilding housing, health, education, science, et cetera. The green sector is transport, infrastructure, energy, and extractives. The blue sector is agriculture, commerce, and industry. The red sector doesn't look as big, but I assure you it is. It's almost $40 billion that is set aside for dealing with unexploded ordnance. So the sheer number of bombs that have not exploded yet, spread throughout Ukraine, delivered by both artillery and drones, is staggering. The amount of artillery that has been dropped on your country that hasn't gone off yet is going to be expensive to deal with. And so that's actually a factor in the rebuilding estimates. The steps that Professor Stereo is going to take you through are reflected in this flow chart, and she'll unpack them in a lot more detail. But what they do is they direct Russian prosecutors, especially if they're using a criminal law process, to go after Russian corporations that are shown to have been involved in some kind of a war crime, how that actually can yield a key to unlock the frozen assets in a foreign jurisdiction. And that key should be able to be inserted into that lock to allow those assets to come back to Kyiv. So I'll turn it over to Professor Stereo to unpack this strategy, and then we'll move on.
Thank you so much. It is also such a pleasure to be here and to participate in this webinar and share more details about this litigation matrix that we have developed. And as Serhii mentioned in his introduction, this was just published last week through the Public International Law and Policy Group, and it's freely available on the web for anybody's pleasure. So I do encourage all of our participants to take a closer look and read the white paper. So the first step here in the litigation matrix is to identify the frozen assets and to essentially disaggregate state-owned assets from privately owned assets. In case you're wondering why that is important, it is important because obviously the state-owned assets are sovereign assets, and if you're trying to go after those assets, you might run into issues regarding foreign sovereign immunity. That issue of foreign sovereign immunity might not be completely insurmountable. In other words, there are exceptions to this doctrine of foreign sovereign immunity, which in some limited instances allow for the seizure of those assets, but it is much more difficult to go after those state-owned assets. And so because of that, we recommend that those state-owned assets be segregated from the corporate assets. The next step then is to essentially only go after those non-state-owned assets, so corporate assets. And then the next step is to match the specific assets to a corporation. We don't spend a lot of time on step number 2 in our white paper because this is largely a technical and forensic expertise. So you need forensic experts to look at the specific assets and try to match them to a corporation. Many times when it comes to these big multinational corporations, they employ various corporate and financial schemes in order to essentially hide their assets and in order to make it more difficult to match assets to a specific corporation. So here we recommend a complex forensic analysis. And in our white paper, we basically explain how it is absolutely possible to match assets to a specific corporation, but it does require tremendous forensic and technical expertise. The next step in the litigation matrix is to then match a specific corporation to a specific war crime, because what we're trying to establish here that a Russian corporation has knowingly supported an entity which has committed war crimes in Ukraine. So here, first, you have to establish that a specific war crime has been committed. In our white paper, we talk specifically about the Bucha massacre, for example, and say, that is an example of obviously a horrific war crime where hundreds of people were murdered. And so we talk about that specific war crime as just an example. Sadly, and obviously there are other war crimes that you can think about. So first you have to establish a specific war crime, then you have to establish who committed the war crime. And as an example, in our white paper, we talk about the Wagner Group as one obvious culprit for many of these war crimes. And then third, and perhaps the most importantly, you have to establish a connection between the perpetrator and then a Russian corporation that has supported the entity that actually committed the war crime. I wanted to mention here that we have examples from other contexts of corporations being prosecuted, being held accountable for the actions of their subsidiaries and entities that actually are complicit in committing war crimes. So I wanted to mention the so-called Lafarge case. So in France, the Lafarge Cement Corporation was prosecuted for the actions of its subsidiary in Syria, which had provided funds to ISIS so that Lafarge could continue operating its cement plant at the same way that ISIS was obviously engaged in the commission of multiple atrocities. And so here, we would need to show that the corporation that's selected for prosecution knew of the entity such as Wagner's pattern of war crimes and continued to support it anyhow. Next in our white paper, we talk about, step number 4 is then prosecuting the prosecuting the Russian corporation in Ukrainian court. And here we actually, in our white paper, we talk about the possibility of civil cases, but we recommend against civil cases and in favor of criminal cases only because when it comes to civil cases, in a civil case, a plaintiff would be seeking a recovery in a Ukrainian court under presumably the Ukrainian civil code for damages. And even if that judgment is then enforced in a foreign jurisdiction whereby Russian assets are seized and then transferred to that particular plaintiff in Ukraine, because we're talking about a private plaintiff, that private plaintiff would presumably then get to keep the money, would get to keep the award's damage as is normal in a civil litigation process. But that obviously means that the recovery could not be used towards the rebuilding and reconstruction of Ukraine. And so not to say that those civil cases are not important, but just to highlight here that we believe that those assets would most likely not be able to be used towards the reconstruction and recovery of Ukraine, which is why we recommend in favor of using a criminal process to prosecute Russian corporations in Ukrainian courts and then to go after Russian assets located in foreign jurisdictions to satisfy those criminal awards and essentially transfer them back to Ukraine towards the rebuilding and reconstruction in Ukraine. We have identified specific sections in the Ukraine penal code So in our white paper, we talk about Article 96, which allows for corporations to be prosecuted in Ukrainian courts. And we identify Articles 109 and 110 of the Ukrainian Criminal Code, which are crimes against Ukraine's national security, and then Article 438, which is war crimes. Professor Kelly and I are certainly not specialists in Ukrainian law, but one of our colleagues, Dmytro Koval, who participated in the white paper is, and through obviously working with him as well as other Ukrainian experts, we believe that we have successfully identified the relevant portions of the Ukrainian Criminal Code, which will allow for the prosecutions of corporations. And we also mentioned in the white paper that under Ukrainian criminal law, there's the possibility of prosecutions in absentia, so that some of these corporate actors could also be prosecuted in absentia in Ukrainian courts. And then the next step in our litigation matrix, in case that there is a conviction in Ukrainian courts, is to then attach corporate assets of the Russian corporation, which are located in a foreign jurisdiction. So basically to enforce the Ukrainian criminal judgment in a foreign jurisdiction and to attach those Russian corporate assets that are located in the foreign jurisdiction in order to then satisfy the criminal judgment issued in Ukraine by the Ukrainian Criminal Court. And in the white paper, we focus on the United States because it is true that many of these corporate assets could be located in the United States. In the white paper, we also talk about where the multiple assets might be located. And it seems that most of the assets are located either in various EU countries, the UK, or also the United States. So in the white paper, then we talk about what that would look like when it comes to the enforcement of criminal judgments in a foreign jurisdiction. And here we focus on two different issues, two different requirements, if you will, towards the enforcement of a foreign criminal judgment. So one thing to note is that there is a so-called dual criminality requirement, that when it comes to enforcing a foreign criminal judgment, the crime for which the entity is prosecuted and ultimately convicted in the conviction state also has to be a crime in the state where you're seeking to enforce that criminal judgment. And so in the white paper, we talk about, for example, war crimes. War crimes is a crime under the Ukrainian Penal Code, as I mentioned, Article 438 of the Ukrainian Criminal Code. It is also, war crime is a crime in the United States. And actually in the United States, we just revised our war crimes statute. And the fact that, so prior to 2002, the end of 2002 in the United States, there was a war crime statute on the books that dated back to 1996. But that war crime statute was a lot more limited. It was also a lot more limited jurisdictionally. And as a result, it was never utilized. In the wake of the Russian full-scale invasion of Ukraine, and the fact that there was bipartisan support for Ukraine in our Congress, that war crime statute was revised and updated at the end of 2002, and President Biden actually signed it into law in early 2003. And the new revised version of the war crime statute is broader and has a broader jurisdictional reach and allows for more, comprehensive prosecutions for war crimes in the United States, so long as there's a minimal connection to the United States. And actually, these are not, corporate prosecutions, but the new revised War Crimes Act was just used for the first time in December of 2023, where a Virginia federal court indicted 4 Russian individuals for allegations of war crimes that they committed in Ukraine. So we know that this act is being used, and we know that for the purposes of satisfying the dual criminality requirement, this would not be a problem. Now, the second step here, when it comes to enforcing a foreign criminal judgment and attaching assets to satisfy that foreign judgment, is that you would need to have, we believe that you would need to have an executive agreement. So basically that when it comes to the United States, that the American executive branch would have to issue a so-called sole executive agreement to allow for this. Now, in the United States, under our constitutional case law, there's precedent for these types of executive agreements, which allow the president, the executive branch, to essentially direct traffic within the federal judiciary with respect to litigation against foreign entities. And so there's a very famous Supreme Court case in the United States called Dames and More, which dates back to the early 1980s. And in that particular case, then President Carter, in order to end the Iranian hostage crisis and resolve that issue, had signed on to the so-called Algiers Accords with Iran. And that was done through an executive agreement which coordinated the release of U.S. hostages with the settlement of financial matters, including the removal of all claims in U.S. federal court to an arbitration tribunal established in The Hague, the so-called U.S.-Iran Claims Tribunal, which still exists today, which is still hearing claims today. And this, power for the executive branch, for the president, was challenged in the United States Supreme Court, and our Supreme Court upheld the president's ability to do this through an executive agreement, deriving executive presidential authority to do this, both from the president's inherent constitutional powers to conduct foreign affairs, to deal with national security issues, but also from a specific statute called the International Emergency Economic Powers Act, better known by its acronym IEPA, which recognizes the power for the president to deal with national security threats. And that statute, IEPA, is widely used today. Most of our executives, when they issue orders, when they issue sanctions against specific entities, the presidents will base their powers to do that through IEPA. And so in our white paper, we rely on this constitutional precedent in the Dames and More case to argue that if it's true that our presidents can, through their executive powers, close the doors to federal litigation in federal courts, it must be true that our presidents can really open the federal courthouse doors pursuant to an executive agreement to allow a federal court in the United States to accept a criminal award that would normally not be accepted, and to do this for the purposes of attaching foreign assets. It's also, important to note, and we talk about this in our white paper, that the United States and Ukraine back in 2001 concluded a bilateral MLA treaty, mutual legal assistance treaty. It was concluded back in 1998 and entered into force in 2001. And in our white paper, we recommend that the executive agreement, which our president would have to issue in this case, should track the language that's already in this mutual legal assistance treaty. And we also point to the mutual legal assistance treaty as another source, if you will, that the executive branch could point to as essentially congressional agreement, congressional acquiescence that the United States should be able to use its courts to assist Ukraine, and in this particular instance, to use our courts to be able to attach, to first seize Russian corporate assets, but then also to attach them to satisfy this foreign penal conviction against the Russian corporation. And then, as we point to in our white paper, the last step here, and perhaps the less complicated step, is then to transfer the seized and attached assets to Ukraine. And here, obviously, the decision would be Ukrainian as to how Ukraine wanted to then accept those assets, and then obviously how Ukraine wanted to use those assets to rebuild and reconstruct Ukraine. From the US side or a foreign jurisdiction side, you would have to know where you're transferring the assets, whether it's the Justice Ministry, the Treasury, the Foreign Affairs Ministry, the President's Office, or perhaps some specially designated rebuilding fund. But those are discussions that Ukraine, obviously, Ukrainian authorities would have to have. And I'm confident that a foreign jurisdiction that's going down this path would be satisfied with the Ukrainian decision, would be willing to transfer the seized and attached assets to the relevant entity within the Ukrainian government. And so all of this to say that we believe that there is this solid litigation matrix, which would allow for, hopefully a criminal conviction of a Russian corporation in a Ukrainian court, but then most importantly, which would allow a foreign jurisdiction such as the United States to then attach Russian corporate assets located in that jurisdiction in order to then use those assets to satisfy the criminal conviction. Because when we talk about criminal convictions of a corporation, we are talking about financial penalties, hopefully significant financial penalties against the corporation. So using the foreign jurisdiction to seize and then attach these Russian corporate assets in order to satisfy the Ukrainian criminal award, and then ultimately to transfer those assets to Ukrainian authorities that would then be used towards the rebuilding and reconstruction of Ukraine. So I will stop here, perhaps turn it over to my colleague, Professor Kelly, to see if he has anything else to add, and then we look forward to all of your questions.
Well, Professor Stereo, I'm never in a position to add anything to what you say, because you always say it all so eloquently. Thank you for that exposition. Just 2 points. First, I neglected when I was introducing our authors to introduce our 5th author, Lydia Korosteleva. My screen did not scroll down far enough. Lydia was essential to the development of this paper because she provided all of the civil code and the criminal code material for us to work with, as well as key points of the analysis. She's a visiting researcher at Harvard University. And then also I wanted to point out, especially with respect to step number 2, the division between state versus oligarch assets. While the oligarch assets are large, $300 billion, the state assets, oligarch assets are estimated at $1 trillion. Only a small portion have actually been identified and seized. And so what's going to become really key to making this work is for financial forensics teams to identify where those assets are, so that they can be accessed. And the European Union has amazing financial forensics capabilities in their treasury and financial institutions, which, if they're not already deployed in this process, and I would be surprised if they're not, should be, and that would, of course, help this engine work. Once you can identify the targets, right, because you've identified the assets and where they're located, then step 3 is where you confirm the targets. That's where you take whatever company you've identified that has assets and match it up with a war crime. That's confirming your target for litigation, and then you move to litigation. So this is an important aspect, I think, that shouldn't be forgotten. And it also shouldn't be forgotten that Ukrainian prosecutors are not on their own in this process. They're not just isolated in Kyiv. They should be working with people in finance and treasury institutions within the European Union to get that financial evidence and match that to the war crimes evidence they're going to be getting from the evidence being collected by the International Criminal Court, which has an office in Ukraine actually physically connecting this evidence. That chain of evidence is going to be incredibly important for a judge in a Ukrainian court, because it's vitally important in your criminal process to prove causation. And proving causation is going to be, foundational to complicity. And complicity goes to the state of mind of the company, and you need that to get to the conviction. So, Sergey, can we turn it back over to you for questions?
Yeah, sure. A few housekeeping issues. Well, first of all, thank you, Professor Kelly, Professor Stereo, for the presentation of the white paper. A few housekeeping issues which I forgot in the very beginning is that those who are watching us live now, you can ask questions on YouTube in the chat, in the live chat. So I will be monitoring it, and if we have any questions, I will put it to the speakers. Then another housekeeping issue, the planned duration of the webinar is from 1 hour to 1 hour and a half approximately, so we do not have any fixed specific limits, but I understand that Professor Stereo will need to leave us at 6 Kyiv time. So we will try to to complete as much as possible within that time. So before moving and discussing the particular steps which are outlined and which are discussed in more detail in the white paper, I would like to ask actually two general questions. So we are speaking about Russian corporates, and that's the name of the white paper, that's the name of our webinar. But just to understand correctly, whether we are limited only to Russian and to corporates, in particular, do you envisage that the same mechanism can apply, at least for the sake of argument, to non-Russian corporations who assist Russia in waging war in Ukraine? And second, does the same mechanism applies not to corporations but to oligarchs, individuals, basically, who may be to a bigger or lesser extent involved again in waging the war against Ukraine?
I think the answer is no in theory, but in practicality, the reason that the universe of what we're looking at was really limited is because that's whose assets are frozen. Sanctions haven't been levied against, Turkish or Brazilian corporations or Chinese or India. And so those assets aren't frozen, so you don't have a target list. So we're kind of working backwards from what's already been sanctioned. But that's not to say that you couldn't proceed, I think, Milena.
Yeah, no, that's absolutely right. And so I think what's important to emphasize here from the perspective of the US is that the US, when the US president uses sanctions against a corporate entity or against an individual, the president can really only do that if they can identify specific constitutional or statutory authority. So basically the president, in a nutshell, the president has to say that there's some kind of a national security threat. There's something that threatens the US national security. And so from a US standpoint, it's much easier to say that when it comes to Russian entities than if you're talking about a Brazilian corporation or if you're talking about, I don't know, a corporation coming from some other part of the world. And so, as Professor Kelly said, the reason we're focusing on Russian corporate assets is that those are the ones that have been sanctioned. When they're sanctioned, they're frozen. What's well established in US law is that the president can issue sanctions and freeze assets, including corporate assets. What we're trying to deal with here is sort of the next step, and that's to say, then how do you use those assets to actually, seize them and then actually transfer them to Ukraine? Because normally, when it comes to the freezing of assets, that's a temporary measure with the idea that perhaps at some point in the future, those assets will be released and they will go back to the sanctioned entity if they're no longer sanctioned. Here we're going the extra step and saying, no, they can actually be attached, seized, and transferred to Ukraine. But to make this practical, we're going with essentially what's already been frozen as the first step.
But with regard to the second question, so it is envisaged to apply not only to legal entities, but also to individuals, although Russian ones.
Sure. There, and in our white paper, you'll see where the seized Russian yachts are and what their values are and where they're currently located. These are assets that can be liquidated. And then, although I'm not sure who would buy them, but nevertheless, in theory, they could be liquidated because these oligarchs are individuals, but they're also incorporated. And personally, even within their corporations, they have corporations. This is how they hide their assets. And so you go after the person, you go after the company that the person is, hiding within to get to the asset. But again, you've got to show that chain of connection to get to it. And a follow-up question, Sergey, that I thought of when Professor Stereo was just speaking. If you were to try to mount a case against a non-Russian foreign corporation that was somehow supporting or participating in a war crime, let's say a Chinese corporation, many Chinese corporations are state-owned. And so they might have sovereign immunity under Ukrainian law. It would only be the privately owned corporations that you'd have to look at.
Well, I think that as a matter of Ukrainian law, the state-owned companies do not enjoy immunity, only the state itself enjoys. But, well, I think this is a distinct question, and generally this discussion moves gradually towards the discussion of the step 1 and step 2 as to identifying assets, matching assets, and I give the floor to Anna to discuss this in more detail.
Thank you very much, Sergey. Thank you very much, Professor Kelly and Professor Stereo, for this great presentation. Indeed, I wanted to discuss in more detail step 1 and step 2. It seems quite reasonably that white paper proceeds backwards from where the frozen assets are and then moves into developing the strategy. And indeed, the white paper presents quite a good collection of data of frozen assets of oligarchs and corporations and Russian banks. So this is all good, and I understand that the key of the assets being frozen is the effect of sanctions. But the sanctions is something that is being evolved. So probably you might know about the project supported by Ukrainian authorities, which is called War and Sanctions. And essentially, they collect data of participation of including Russian and as well as non-Russian corporations, people in assisting Russia in waging aggressive war against Ukraine. And so the sources of information from this database underpins the imposition of new sanctions by Ukraine, and Ukraine usually proposes to its partners in the sanction coalition to adopt sanctions as well. And here I was just wondering whether you see an opening for a pre-step 1, for instance, if you see a person who assists the commission of war crimes committed by Russia, whether the first step you could initiate imposition of sanctions for the sanctions to work as the freezing injunction effectively, to freeze the assets until you have time to obtain a Ukrainian judgment, either criminal or civil, and then to try to enforce on the assets. So that would be my first question.
So Anna, that's a very interesting question. So could, for example, let's use the United States just as an example of a foreign jurisdiction. Could the United States issue sanctions towards an entity that we identify in step 3 as an entity that has assisted in the commission of war crimes?
Yes, exactly. So that was an idea. If you identify a person, a private person that assists committing international crimes, that's probably from the policy perspective, if something you want to sanction as well, because they have been playing on the field together with Russia. So if you do identify those, you can use a tool of sanction as effectively a freezing injunction, just to win some time to develop the strategy of litigation.
Yeah, in theory, yes. Again, the issue is that, for our president to be able to issue sanctions, the president has to say this is somehow a national security threat to the United States. So you can, so long as you can create that kind of a linkage, then yes, the United States could issue sanctions. But sanctions can't be issued for, there has to be some reason. Now, I would add, this is maybe like a bad example, but I think could be used here. But let me explain. Under the Trump administration in the United States, President Trump issued sanctions against the then prosecutor of the International Criminal Court, Fatou Bensouda, arguing basically that the court and Fatou Bensouda herself was a threat to the United States. And again, sanctions were issued against her as a person, against her individually, not against not against the court or some other corporate entity, but against her personally. And so now we have that was obviously, I would argue, horrible and a bad foreign policy decision. But we do have precedent in the United States of the issuance of sanctions in cases where that linkage between the person and the national security interests of the United States is tenuous at best. So I think you could use that precedent to argue here that a person who has committed war crimes in Ukraine is a threat to the United States for some reason and can therefore be sanctioned.
But it's not worth the effort to do the sanctions unless you have the assets.
Exactly.
So
exactly.
You want to make sure that there's some assets to freeze. And in the case of the prosecutor at the ICC, Fatwa Bensouda, there were no assets here, of hers to be frozen. The ICC has no assets here. It was for political purposes that was done. So that wouldn't help, in this process. You would have to identify some other company that was helping a Russian corporation to then also help an entity that's committing a war crime that also has assets. Otherwise, it's not worth your time to do the sanctions because you won't have anything to collect at the end of the day.
And I think, and that's important to emphasize, because the one of the main goals of this white paper is to go through this, identify this litigation matrix, but with the end goal of actually being able to collect assets that can be used towards reconstruction and recovery and the rebuilding of Ukraine. If you're sanctioning an entity or an individual that doesn't actually have assets in the United States, you can do that for political reasons. You can do it because it becomes incredibly cumbersome and burdensome on that person. So you can use that asset to maybe, you can use those sanctions to maybe dissuade that person from engaging in that kind of a behavior again, or to send a message, but you're probably not going to be able to recover any meaningful assets that you can use towards reconstruction and recovery. So I think that could be a step, that could be something you can do, but for a different purpose, which would again be more about dissuading others in a similar position to act that way because they would risk US sanctions. And I would add, though, that persons who are sanctioned by the United States, even if they don't have significant assets in the United States, so even though we can't talk about like collecting their assets, I read a statistics that about 90% of all world financial transactions are conducted in US dollar. So even if you live in Ukraine or you live anywhere in Europe, most of your like credit card and other financial transactions are conducted in US dollar. So if you are sanctioned by the United States, it is incredibly burdensome and cumbersome on you personally. But again, we're talking about a very different situation and something that wouldn't necessarily be helpful if you're trying to get funds to use towards reconstruction.
Thank you very much. I take it, maybe my question was not like full enough. I meant only kind of to institute the sanction process only if you see that there are assets in the jurisdiction. But moving to step 1 and step 2, I would invite you to elaborate a little bit on what would mean identifying assets. So obviously, the white paper discusses a question of hiding assets and using affiliates or various shell companies to hide the assets. So, and the number of frozen assets is maybe various with different type of the assets. So what you envisage in what would mean identify a proper asset in terms of both the type of assets and probably the legal title to that assets, or who is holding the assets, and what that company or a person, what connection it has to ultimate defendant in the contemplated litigation. This might be a little bit of kind of targeting in both the step 1 and step 2, but if you could elaborate on this, that would be helpful.
Sure. I think what you want to do is figure out what's in the net that you've cast. We've cast this big net of sanctions. Now we need to look at the fish that we've caught in our net in Tokyo, in London, in Paris, in Berlin, in Rome, in Madrid, in New York City, and figure out what companies are there and how their assets are being managed. Because if you freeze an asset, you have a duty to continue investing that asset. So if we seized, $1 billion from a Russian corporation, and that $1 billion is sitting now for 2 years in New York City, it's ostensibly being managed by somebody in the Treasury Department and invested so that it's worth $1.3 billion now, because it doesn't just stay there. You have a duty to make sure that money is used. So measuring the assets, identifying who owns the assets, and then taking that identity and matching it with some war crime that's happened in Ukraine. And the evidence that the International Criminal Court is collecting now is going to, again, work backwards through that chain. So when the ICC is looking at all of the things that happened and Professor Stereo mentioned the Bucha massacre, we know who participated in that. 3 Russian airborne divisions and the Wagner Group. Who is supporting the Wagner Group? 5 different Russian corporations, some of them with material, some of them with investments, some of them with direct financing. Did those companies know that the Wagner Group was committing war crimes while the support was happening? Yes. If you can say yes, then you can go ahead and proceed to the prosecution and show the connection that the Wagner Group would not have been able to commit the war crime but for the corporate support. If you take that away, then the war crime wouldn't have happened. And that's when the judge agrees with you that there's a connection and they're, complicit or aiding and abetting or whatever the profile is for that the prosecutor chooses. So absent step 1, step 2, and step 3, you can't have a case because you have to show that connection all the way through. And step 1 is arguably the most important, because if there's no assets, there's no point in proceeding with the prosecution, because you're not going to get anything back for the rebuilding process if that's your whole goal. There may be other reasons to do it, accountability, like Professor Stereo said, or dissuasion for companies to participate in the commission of these war crimes, especially if they're enabling processes. So you think about the Russian trains, right? And the corporations that own the Russian part of the Russian railroads and trains that were used to transport kidnapped Ukrainian children out of Ukraine into Russia. And then they get back on those trains and they go to different families and they're, deposited there. That's all a war crime. And it couldn't have happened without that transportation system. And they knew that they're dealing with abducted children. And so if that railroad company has assets in Tokyo or Paris, 2 big railroad cities that are frozen, then that's where you're going to want to target trying to get those assets back.
Thank you very much, Professor Kelly. I think we're moving gradually to step 3 and step 4, and I would like to pass the floor back to Sergey.
Thanks, Anna. I just had a few follow-up questions on the step 1 and step 2. I do understand that, well, basically this is a complex process and this is not something that we complete step 1, then we only move step 2. So we probably need to look at it more holistically, saying that, okay, we identify the potential perpetrator or the abettor of some Russian corporation, and then we check whether it has the assets and whether these assets are within this net, as you described. You mentioned that the issue of the sovereign immunity. So are we talking about here about only Russian private corporations, in the sense that they are privately owned and not related to state? Or are we talking about some broader category as like legal, like separate legal entities, even like maybe joint stock companies, even if they are fully or partially owned by the state? So the same example is the Russian railroad. So it's a joint stock company that is owned by the state 100%, I believe. Can we still count on finding the assets such that ultimately we can get those assets if the judgment is rendered against them, or is this will be prevented whatsoever by sovereign immunity?
So that depends. The answer is yes and no. That depends on, in Ukraine, under Ukrainian law, if sovereign immunity is going to be a problem for prosecution. If it's not a bar for prosecution, then you can proceed. But you have to be careful about the law of the foreign state where the assets are controlled. So if you take that judgment to Paris or Tokyo, and under French or Japanese law, the Russian railroad assets are considered sovereign assets, then they might treat them the same as the Russian central bank assets. And that would be unique to that particular jurisdiction. So you have to be careful to research both before you proceed.
And what is the position under US law? Well, let's stick to this Russian railroad.
Well, under
example.
US law, you have an act, the Foreign Sovereign Immunities Act. Actually, and Professor Stereo mentioned this earlier. And the act lays out exceptions to foreign sovereign immunity. One of the exceptions is the commercial activity exception. And so if the entity is engaged in commercial activity, that could open up exposure for them. I don't know, Professor Stereo, do you want to explain a bit more about commercial activity?
Sure. So the Foreign Sovereign Immunities Act in the United States, I think is fair to say, is a fairly complex legal area. But generally speaking, as Professor Kelly just explained, if a corporation is engaged in commercial, if the state entity, not the corporation, if a state entity is involved in commercial activity, then the theory is that sovereign immunity no longer applies because that state entity or sort of pseudo-state entity is no longer engaged in sovereign acts, which are entitled to this presumption of immunity, but instead it's acting as if a private actor would act. So for example, if a plaintiff in the United States is trying to sue a foreign sovereign corporation, let's say like the Russian-owned railroad corporation, because that railroad corporation has dishonored a contractual obligation, the theory is that that lawsuit can proceed because now you're not suing that state entity for something that they did in their capacity as a sovereign. Instead, you're suing them because of their commercial activity. And so here, I think when it comes to, for example, a Russian sovereign or pseudo-sovereign entity like the railroad corporation, and you're using the trains towards the commission of, to somehow assist in the commission of war crimes, is that a sovereign act or is that a commercial act? That would be the threshold issue. In the United States, there is litigation on this when it comes to, for example, the return of the Nazi stolen art. There's a very famous case in our Supreme Court called the Altman case, where plaintiffs in the United States were able to sue essentially the government of Austria to claim the return of art that was seized in Austria by a pro-Nazi Austrian regime before World War II. And in that case, our Supreme Court said basically that there was no foreign sovereign immunity. So unfortunately, I'm gonna have to leave it at that. I know you're in great hands with Professor Kelly. I have another engagement for the United Nations that I have to jump over to that, but it was such a pleasure being here today. Thank you so much.
Thank you very much, Professor Stereo. It was great to have you on the webinar. Okay, so now we basically can move. We don't have much time left, that much time left. I think we can move to steps 3 and 4, and I appreciate that it actually will involve in practice a lot of Ukrainian law questions rather than foreign law questions or international law questions. And I think we can leave aside those Ukrainian law questions to the extent possible and for some separate discussion on this. And on those steps, I would like just to ask a few specific, or test a few specific scenarios, whether you think they can work within the framework of suggested by the white paper. So the first one is you and Professor Stereo explained the significance of why it should rather be criminal prosecution than civil, so that the state could ultimately get the funds and for rebuilding. Well, I think that from the perspective of Ukrainian reality of how like many things are organized in Ukraine, I think the important point to bear in mind is that a lot of assets which were destroyed and a lot of infrastructure like transport, energy, and all those things which were heavily damaged and need to be rebuilt, they are not held by the state directly, but they are held by various state corporations. For example, well, all Ukrainian grid is held by the state company called Ukrenergo. Ukrainian Railroad is held by another Ukrainian state company. We have huge oil and gas extraction companies, other energy generation companies. Most of the energy generation companies are actually state-owned companies. So my point is that ultimately, if the state gets money for rebuilding, the state will need to give this money to some of these state corporations so that they could rebuild infrastructure. So in this context, can we say that the ultimate purpose of this exercise still will be preserved if such state corporations who suffered like billions of damages, instead of taking criminal route, they bring civil law claims and get judgments in their favor, which can be used for rebuilding?
Yes, I think you're right. In the ultimate aim might still be satisfied, but the logic that stems from February 2002 to today is that the Russian invasion of Ukraine was a crime. And so everything that has happened since February 2022 is by extension a crime that the Russians have committed. Anyone who participates in it is a criminal, whether it's the Russian soldiers, the Russian corporations, any apparatus that supports the invasion is criminal conduct. And so you want to keep the logic of that, I think, seamlessly from February 2022 to today. And so that's another preference for the criminal track because it paints the Russian corporations as criminal by engaging in these acts. And in theory, I don't know if this is true in practice, but in theory, corporations pay a price if they are convicted corporations, right? And they have that label of engaged in criminal acts. That has a terrible price on their corporate reputation, and they want to avoid that as much as possible. Again, I'm kind of projecting theory into practice here, and I don't know how that plays on the ground in Moscow. Maybe they don't care. But you are quite right, Sergey, that the civil track could ultimately get us to the same point, just not in with the same sobriquet attached to it that I think is symbolically meaningful for Ukraine to consistently say this is a crime and we are the victims of a crime and these are co-perpetrators of the crime against us.
Yeah, right. Well, as I said, there can be, and well, this is also discussed in the white paper, there can be numerous questions of Ukrainian law if you would like to bring this before the Ukrainian court, in particular via criminal route. And therefore, I think the civil route still, well, should not be discarded because it's not serving the purpose, because it actually can serve the purpose. So obviously there can be individuals who will be suing, who can try to sue Russian corporations again and get compensation for their suffering, but mostly that really will be Ukrainian state-owned companies whose infrastructure suffered, whose all assets suffered, and whose infrastructure is actually necessary for the survival of the state, and for functioning of the society, and for basically it will need to be rebuilt ultimately.
Yeah, no, I think you're right. And we do offer it as a possible, litigation track in the paper, but the other thing is capacity. And so for, the Ukrainian corporations, they will have the capacity to collect the evidence and match, where identified assets are in foreign jurisdictions, and work with the ICC to make the match for the war crime. But an individual Ukrainian who owned, an apartment building hires Anna Chakova, one lawyer, to litigate a civil case. As much as I'm impressed with Anna, she does not have the capacity to build a case and travel all over the world matching assets and doing the forensics necessary to show that the company was still supporting the entity through its financial transactions. And she's not going to be able to get the banking records out of Switzerland like a company can, or like the Ukrainian state can when the prosecutor's building a case. So it would be great if they could do that. I just don't know that they would, 100 Ukrainian lawyers representing 1,000 individual Ukrainians is going to have the capacity to do that.
Right. Yeah, that's absolutely true. So another potential scenario which I would like to test, Ukrainian courts and under Ukrainian law, during the martial law, which is now, they are entitled to confiscate the assets that have been previously sanctioned by Ukraine, if the owner of those assets takes actions to further Russian aggression. So there have been such examples. This is not strictly speaking a criminal route, because we do not have a criminal procedure here, but this is a very special mechanism of special confiscation, if we can say so. So do you think this mechanism under Ukrainian law, so and just to avoid doubt, this is done by the decision of the court, so this is not an executive decision, this is done by the decision of the court, and the court make the decision if the assets are frozen previously, so if they are sanctioned, and if the owner furthers Russia's aggression against Ukraine. So it's not the war crime test, but Russian aggression test. So basically, do you think that this mechanism can be potentially implemented in this procedure suggested by the white paper?
Perhaps. I'm not familiar with that procedure. Is it based on a theory of treason against the Ukrainian state?
I don't think it is based on any specific theory.
Yeah. And I mean, I would imagine it would mostly have been used for those who supported the Russian aggression in Crimea, Donetsk, Luhansk, the Russian speaking individuals who are collaborating with Russia, or I don't know, maybe not.
Yeah, no, go ahead.
Yeah, just to add a bit of details here. So the procedure is provisions in the Ukrainian law on sanctions, and it's applicable only during the martial law. And effectively, the Minister of Justice brings the relevant claim through so-called administrative court proceedings procedure. And then you would have a decision of a specialized Ukrainian court saying that right, these assets belong to a person who I've been shown to have assisted Russia in furthering the invading aggressive war against Ukraine. So I hereby pronounce that these assets should be seized and then repurposed seized for the benefit of Ukrainian state, and then the proceeds of these assets, as the law provides, goes to the state budget and special fund devoted to reconstruction of Ukraine. So it would be a decision of Ukrainian court effectively confiscating assets. And if that decision could say, okay, I confiscate not particular assets of particular individual, but I would like to confiscate assets of this corporation, whenever they are located, because that corporation furthers Russia aggressive war. Do you think that would work under the mechanism?
Well, it depends on the receiving jurisdiction. In another civil law jurisdiction like Italy or Germany, perhaps, but in a common law jurisdiction like London or Washington, D.C. or New York, the receiving judge, when they look at an order, they get to review it. And there has to be a fair process. And if they don't see that there was some kind of a trial, with an adversarial component, then they're going to be a little more skeptical about the fairness of the process in order to release the funds. If it looks like it's widely adopted and fair, and everybody agrees with it, and the international community has blessed it, then perhaps. But again, I don't know enough about it. I do know that on the receiving side, the court that receives the request to unlock the assets will look at the underlying process. And if this passes muster, then, it could. It's more likely to in a civil law country, I think, than a common law country.
Right. But just to say that this specialized court runs the proceedings really up to the standards. So the procedure, the hearings, even video recorded and available online. And the defendants, they are represented by legal representative of their choosing. And so from the procedural perspective, it looks
maybe
solid.
so. Maybe so. That's an interesting aspect I was not aware of.
But I think the other critical point is that let's put it that way. How critical, and probably we are now moving gradually to step 5, but how critical is it for the ultimate judgment to be recognized in the US? Let's talk only about the US. How critical is it that the underlying judgment must be based on some criminal misconduct, on some criminal illegality, in a sense that if this judgment on confiscation of Russian assets rendered by Ukrainian specialized court, if it relies on the Ukrainian special legislative provisions on sanctions, which are related to the furtherance of Russian aggression, which is generally a crime, but the basis for confiscating those assets by Ukrainian judgment was not this confiscation was not premised on the criminal misconduct.
Yeah, so from a conflicts of law perspective, actually, it's not very common that courts will enforce the penal judgments of another country, absent an agreement to do so, which is why we need to have an executive agreement. Because the normal rule is that you don't enforce another country's criminal law, because to do so, you're taking their sovereignty and exercising it on their behalf in the penal system. So it actually is, Sergey, the more normal route that civil law judgments and arbitration awards are used in foreign jurisdictions to attach assets. In fact, the international arbitration system is what inspired this white paper. And this is what you do in the Ukrainian Arbitration Association all the time. If you go to Switzerland and arbitrate a case, against a company in Mexico with assets in New York, you take that award from Switzerland to New York. You present it to a federal judge. The federal judge looks at the arbitration process, approves it, and then seizes the frozen assets to satisfy the judgment. So actually what you all do in arbitration every day was the inspiration for this white paper as the legal process. We're just adapting it to a criminal law process because war crimes are the underlying activity, and we felt that criminal prosecutions logically made more sense for the Ukrainian state. But you're absolutely right. Normally, penal law judgments are not enforced by other states. So that's why you need an executive agreement of this type to make that happen.
Moving slowly to step 5, and then the need for this executive agreement or executive order. And essentially, in my mind, that would be a circle back to step 1, because essentially, if you have a criminal decision, but you don't have an executive order, then even if the assets are in jurisdiction, you would have difficulty of enforcing on these assets. So in terms of the timing of this executive agreement or order, when is best to secure it in place, like before you start the litigation process, or it's something that needs to be done post factum after you have a criminal conviction on hand?
I think it needs to be done. And again, this is just, even though the white paper focuses on the United States and uses a lot of the analysis from the United States, this is a template for other countries to use. So the answer to your question, Anna, is going to be different if we're talking about France or Japan or the United Kingdom. If we're talking about the United States, it will be important for us to have an executive agreement in place between the United States and Ukraine before November of this year. You may be aware we have a presidential election happening in the United States. You may have heard. And so this is one of those things I think that should be done before then, if we're going to proceed down this road. There already exists, as Professor Stereo said, a mutual legal assistance treaty between the United States and Ukraine, and it's been around for 20 years. And so this executive order would be issued pursuant to that existing treaty, which means it's an Article 2 executive agreement based on a treaty, which means it has much more legal weight than a sole executive agreement that is issued just by the president himself. And I think, if we're going to do this, we don't want to roll the dice and wait and see what happens in November, because we may get a new president who might not be willing to do this. So I think we need to do it while we can.
Right. Thank you very much. I have one technical question, and it goes to something Professor Stereo has outlined in the presentation, that and in particular that US have adopted or updated the America's War Crimes Statute in late 2022, and it was enacted into law in 2023. And so, example you're discussing in the white paper, for instance, Bucha massacre, it happened during the first years, so the first months of full-scale invasion, so essentially beginning of 2022. And in terms of temporal aspect, so would it create the problem if you prosecute some corporation for assisting in committing war crimes in Bucha, which happened in the beginning of 2022, and then be able to establish dual criminality in the US?
That is an excellent question. And it depends upon what the court decides to do. On the face of it, no, because you don't want ex post facto judgments and retroactive statutes. There's a presumption against that, but it's a rebuttable presumption. And so the court may say, yes, the underlying crime itself, the Bucha massacre, was still a crime under the old US statute and the new US statute. And so it's not a problem. The only question was whether or not corporations could be, ensnared as perpetrators for prosecution purposes. That could go either way, but the Supreme Court has applied statutes retroactively before with respect to international assets. And so Professor Stereo raised the Altman case, where the Nazis seized artwork in Austria, and a litigant from California sought to bring a case. And she brought a case that applied a statute that was not in force in the 1940s when the painting was seized. The statute didn't come along until the 1970s, 76. And so Justice Kennedy in the Altman case said, well, yes, there's a presumption against retroactive application of a statute with respect to seizure of assets, but we're going to overcome that presumption and allow the case to proceed. And so that's what they did. So they can if they want to. And so I don't know the exact answer to your question. I know there's a pathway for it to still happen, even for, atrocities that occurred during the 2022 period before the 2023 adjustment to the American statute was made.
Thanks, Professor Kelly. I don't see any questions on the chat, and I don't know if that's because there is no question or because something wrong with the chat or with my web page. But I think we can conclude at this point because we're basically reaching the time limit that we initially anticipated. So thanks very much, Professor Kelly, for joining us today on this webinar. Thanks a lot more generally from the Ukrainian legal community for working on this white paper and working on this initiative, which seems to be greatly important generally for Ukraine, and I think for all the initiatives on rebuilding and reconstruction of Ukraine, which will need to be funded somehow. So seizure of the Russian corporate assets is definitely the point that needs to be investigated, given the amount of frozen assets. So thanks once again.
Thank you very much.
Thanks. Also thanks to my co-moderator, Anna, and thanks to Professor Stereo, who already left the webinar. Okay, so that's probably the point where we conclude. Everyone from the audience, thanks for joining us, and everyone who will be watching us on YouTube or this webinar recorded. So hopefully you will find it helpful. So thanks again, everyone, and have a good evening.